Hi everybody, this is the video lecture from class on the 6th today, the one that we were going to do in person but unfortunately had to pivot and now will be online. I appreciate your flexibility. The disadvantage to pink eye is that it's super contagious, so daycare is very strict about kids not being there for a certain period of time and nobody wants to come watch your kids because they don't want it either. So I'm home with my lovely 2-year-old who is gunky and itchy, but hopefully we'll be on the mend soon. So the focus of today is to talk about legal obligations that we have as social workers and how that relates to ethics and how it can present ethical dilemmas. Really, these legal obligations, there's 6 of them, are driven by the Code of Ethics, and kind of the conditions and the expectations that are outlined in there are really driving these things that we are responsible for legally offering to our clients. So we're going to go through 6 of them. This first video is going to, hopefully I'm going to try to get through the first 4. Then following the video, there is going to be like an application type of exercise where you'll have to discuss each area of duty, about where you specifically find it outlined in the Code of Ethics. You'll have to access the Code of Ethics and then discuss how an ethical dilemma might present itself within that topic. So it'll make more sense, I think, as we go through. But if that's just kind of the lens you want to be thinking about as we go through, that's going to be the obligation after the video. So here are our 6 legal obligations as social workers. We have duty of care, duty of privacy, duty to maintain confidentiality, duty to inform, duty to report, and duty to warn and protect. So here we go. The first one is duty of care. And so as a social worker, we are obligated to provide reasonable standards of care when delivering our social work services. And to me, this kind of sounds like, well, duh, shouldn't everybody provide a good standard of care regardless of their profession? Why are we even saying this? Isn't this something that is expected? And I would say yes, that should be a reasonable expectation for any profession. But it tends to be super important within the social work profession because we are interacting with humans and humans are vulnerable. And so it needs to be said that if you're going to be providing services for a human being, it needs to be at an appropriate standard to eliminate and reduce any potential for harm. So clients have the right to expect that if they're coming to you for services, that you will discharge or implement your professional responsibilities in a competent manner. This is kind of an implied contract. You're not necessarily signing anything saying, I promise to be a competent social worker. It's kind of this unspoken expectation that clients can have when they come to see you as a social worker. And so essentially what that means is that if you are providing some sort of service, so like if you're thinking like in a therapy setting and you're telling your clients that you are able to provide them with cognitive behavioral therapy, that means you know actually how to implement CBT, that you've been trained, that you understand it. It's kind of like if you're going to go if you were a doctor, you should go to med school because your patients have an expectation that you know what you're talking about, that you're not just Googling something and pretending to be a doctor. So essentially any service that you offer your client needs to be something that you're competent and prepared for. Yes, honey. Hi. Hi, babe. Is that a ball? Okay, I gotta teach, okay? So when this would come into play is, let's say you are working with a client and something comes up that isn't necessarily in your scope of practice, but your client really wants you to continue to be their provider. So this might be, let's say, like if you are seeing them for housing services, let's say, but then they disclose to you that they really want to get sober and that they would like you to be their counselor. Well, that's not your job duty. You're their housing case manager. And so you have to make sure you're practicing within your scope of your role and within your scope of your duties. It helps create good boundaries. It helps connect them to appropriate services because in the moment it might sound good, but realistically, that's not something that is going to be beneficial long term. So if we were in class, this is when I would ask you, when might duty of care present an ethical dilemma? So that's going to be on the Google Doc that you have to fill out. So so something to think about understanding this content from the duty of care. You're going to have to share when you think duty of care might present an ethical dilemma. I just kind of shared one. Can't use that one. You'll have to think of something different. All right, the second one is duty to privacy. So as a professional social worker, you have a duty to respect the privacy of the people you serve. So this kind of, again, I feel like is a duh thing, but it is easy, and I've been guilty of it, to do a Google search or a Facebook search on your clients for no purpose other than mere curiosity. It isn't necessarily to help them clinically or to problem solve. It's just because you're being Snoopy McSnoopsters and you want to know something. And so ethically, that is not something that you are supposed to be doing out of respect for clients' privacy. So under most circumstances, you're not entitled to intrude on the privacy of prospective or current clients. You might create some sort of bias if you're looking at them, seeing the things that they like. You might see pictures from years ago that have nothing to do with who they are now. And then again, you have an unfair bias. And so those are things that you just want to, out of respect for your client, to not come into any sort of session or interactions with those things already planted in your head. And so it's good to know that privacy includes individuals' physical space. So going into their homes uninvited, you don't have the right to do that. Now, in some cases, it might be part of your job. So if you're a probation officer or if you're doing CPS work, you might have a legal right to go do it as part of your job duty. But for purposes outside of your job duty, where it's requiring you to do that, you shouldn't be going around and snooping in their home. You can tell that some of this content was taken from an older PowerPoint because I don't know that the clients have lockers anymore. Their car, a wallet or purse or clothing. So when they come into their session and they happen to go to the bathroom and leave their purse in your office, can't go through it. So other areas of privacy are aspects of their personal life that constitute a symbolic religion, which is that person's alone to share or reveal if he or she does not seem fit. So if you are if you've observed them wearing a certain necklace, or if you're in their house and you observe like some sort of religious stuff on their walls, it's up to them to disclose if they want to share that or not. So making sure that you're respecting their privacy as well. So the reflection question is, when might duty of privacy present as an ethical dilemma? I think the biggest one that I can share is doing those social media or Google searching for mere curiosity's sake versus being productive. I had that one time where I had a client and he was in a housing program. One of the things where one of the requirements was not to use any sort of drugs. So at that time, marijuana was not legal. And we couldn't find the client for a while. He wasn't answering our phone calls. So we decided to do a Facebook search on him. Found his Facebook. We started doing a deep dive into his Facebook to see if it had been active lately. We probably dug a little bit more than we needed to. Well, then we found him talking a lot about his marijuana use, a lot of like marijuana memes being shared. So we're like, shoot, now we know that he's using, but that wasn't disclosed to us. Now we have this dilemma of we have this information that we were given not by him, and it might impact his ability to continue in housing, but he hasn't shared it. So how do we navigate that? We obviously can't use it against him because it wasn't something that he shared with us. We found it out via a third party. But then I kind of always had a tainted perception of, is he lying to us or is he not? Because he said he wasn't using, but his social media showed otherwise because I did a search and invasion into his privacy. It started out as good intended. We just wanted to see if he was active on social media to see if he was still around. But it turned into something that was not productive, and I will take ownership that was not very ethical of me. All right, the third one is duty to maintain confidentiality. So the laws that certify or license social workers require that all information shared by clients remain confidential. This is kind of one of the first things that we preach to you when you become social workers, is what is shared with you stays between you and the client. Obviously, you have times where you have to break confidentiality, harm to self, others, someone's harming them. We also talk in individuals and family how sometimes, you might have to share something with your supervisor or have your sessions videotaped for supervision reasons, those types of things. But in general, anything that is shared with you and the client stays between you and the client. To kind of expand on that, in general, material shared by clients is their property, not the social workers. It's not yours or your sponsoring organization or your agency's, even though you record it in a case record, and that again is for liability's sake. But the intent of recording it is to help serve your clients, not to use as a resource or share with others outside of what the scope is appropriate. So you can obviously share confidential or information from a client if they sign a release, but without that, you are not allowed to. It's good to keep in mind that it does not simply become your property because you heard and recorded it. Again, it is the client's property that they have shared with you. And under most circumstances, clients must give informed consent before you may share information with another person or organization. And something that's always helpful to remember if they've signed a release is that still you want to share the least amount of information possible. So if they've signed a release for you to talk to, let's say their parents, if they're like in college and you have a release to talk to their parents, you don't need to tell them everything that their son or daughter has shared in a session. Just the least amount of information that's going to be helpful for whatever's going on, because that does help build trust with the client, and it does continue to show that you're respecting their confidentiality. So when might duty to maintain confidentiality present an ethical dilemma? I'll let you guys think of that one, because there's a lot of that. All right, duty to inform. You're obligated to educate clients and prospective clients concerning the nature and extent of services you and your agency offer. So under HIPAA, you must also inform clients about privacy practices. HIPAA is the Health Information Privacy and Protection Act. If you've worked in any sort of medical field, you'll hear HIPAA ad nauseum. It comes up all the time. And so some of the things that we're required to share is how much services are going to cost, length of treatment, the risk, probability of success, and alternative services that might be appropriate. So I'm going to actually go to this slide. So I know I didn't teach, I think most of you individuals and family, because I was on maternity leave, but this is taken from my materials from individuals and family, because when we teach you all how to give your client informed consent, these are the types of things that you reasonably should be sharing with your client, and a lot of these are actually in the code of ethics. And so you just want them to know upfront what to expect. So the type and structure of therapy, what will happen, what you expect from them as a client, length and cost, when you're going to be missed appointment policies, after hours supports, what termination of services look like, and what their client rights are as a client. This is all kind of to go along with self-determination, because it's going to allow the client to determine if they do or do not want to engage in services. It helps build trust because clients know upfront what to expect from you and from your services. It's just to empower clients with as much information as possible so they know what to expect moving forward. If you think about trauma care, a lot of components of like trauma-informed services is that clients have predictability and don't have surprises. And so this really helps to kind of eliminate any potential trauma and to build a sense of security with your clients. I also threw on limits of confidentiality. This does connect back to the previous duty we just talked about. When confidentiality is limited, you can see it's more than just harm to self, others, or someone harming them. Might be videotaped, supervision. You sometimes have to release your notes to insurance to justify and validate why the clients are coming to services, so they'll pay for it. You might get subpoenaed from some court hearings, so you might have to release. But again, release the bare minimum possible for the situation. So pop back to this slide I skipped over on duty to inform. You should also provide information concerning relevant policies and laws that could affect clients during provision of social services. So if something's coming down the pipeline where like Medicaid is going to get cut off or Medicaid eligibility is changing, you're going to want to let clients know that that might interfere with your services. You should also inform clients that should a person's life be at risk, you intend on taking action to protect that person. even if it means violating confidentiality. We'll actually talk about that in duty to warn, because that is one of the duties as well. All right, there you go.